Okay, imagine this scenario. You're a dedicated employee of the Postal Service doing your job, and unfortunately, you suffer an injury while on duty. You see your doctor, and they confirm you have medical restrictions. You can't perform all your regular tasks. Then comes a tough moment. Management reviews your limitations and informs you. There's simply no suitable work available right now that fits what your doctor says you can do.
Right.
You're sent home. It feels like you're in limbo. What happens next? How do you even start navigating this complex situation?
It's a really challenging position for any injured worker, and happens, well, more often than people might think within systems like the Postal Service. It can feel incredibly isolating.
Absolutely. And that feeling of being lost in the system is exactly why we're doing this deep dive today. We've gone through a stack of sources. We're talking official USPS policy, like the Employee and Labor Relations Manual, federal regulations that govern federal employees, guidance from unions representing postal workers, and important arbitration decisions that have clarified these rules.
Yeah, those sources are key.
Our mission for you is to extract the absolutely essential knowledge from these sources, cut through the jargon, clarify the obligations, the forms, and most importantly, your rights when you find yourself in this very specific no work available situation after an injury.
Precisely. This area is governed by specific, robust rules designed to protect injured employees and ensure they have a path forward, even when their typical job isn't an option. Understanding these rules is really your first step.
So let's unpack this. What is the very first thing the Postal Service must do when one of its employees is injured on the job and can only work with medical restrictions? What's their initial obligation according to these sources?
Okay, the core insight here is that USPS has a significant legally mandated obligation. Federal law and the ELM, specifically Section 546, don't just suggest, they require USPS to make every effort to find work for an injured employee who is partially recovered and has medical restrictions.
Every effort.
Yes, and this duty applies to all employees, regardless of their craft or status, if they were injured on the job.
Every effort sounds strong. But what does that actually look like on the ground? Do they just, look around and say, nope?
No, not according to the rules. ELM Section 546.142 lays out a specific step-by-step process, a sort of priority search. The first place they have to look is within your own craft, at your normal facility, on your regular shift.
Okay.
The goal is to keep you as close to your pre-injury work life as possible while respecting your limitations.
Okay, start at home base. What if there's nothing suitable there? Nothing in your craft, same shift, same building.
Then they have to expand the search. They look for other work within the same facility that fits your restrictions. This could involve assigning you tasks outside your usual craft, using any productive duties available, as long as they stay strictly within the doctor's prescribed limitations.
So they could have you doing something completely different just in the same building.
Yes, exactly. And if that's still not enough work within the facility, they are supposed to look at different shifts or schedules, although the sources suggest they should still try to keep your hours as close to your original schedule as possible.
Right.
Only as a last resort are they supposed to search nearby facilities outside your home office. The process is designed to exhaust options, prioritizing keeping you employed and close to home if possible.
Now, here's where it gets really interesting based on the sources.
Yeah.
There's this concept, particularly clarified through arbitration, like the famous DOS decision, that they can use make work. Does USPS have to find you an existing established job opening?
This is a critical insight and often misunderstood. No, USPS is not required to find or create a permanent established position just for you. They don't even have to limit assignments to tasks that are strictly essential to current operations.
Okay.
What they can and must do, if necessary, is create an assignment by pulling together a collection of tasks, essentially make work, that are uniquely tailored to fit your medical restrictions. The key point is they cannot refuse to place you simply because the only tasks available don't add up to a standard job description. Their duty is to match the work to your limitations using whatever productive tasks are available.
Wow, so they can literally invent a job description for you using bits and pieces of tasks just to keep you working within restrictions. That's quite an obligation.
That's the essence of the obligation under ELM 546 for partially recovered employees. It stems from the broader requirements of the Rehabilitation Act, which mandates reasonable accommodation for employees with disabilities unless it causes undue hardship.
Right, reasonable accommodation.
And ELM 546 is USPS's specific way of applying that principle to employees recovering from job injuries.
And how do they prove they've actually done this extensive search? Made that every effort?
This is where documentation becomes key. Management is required to conduct these searches thoroughly across crafts and hours, and importantly, they must document their efforts. They typically use internal tools like a 546 worksheet or priority for assignment worksheet. This paperwork lists who they contacted, what potential work they considered, and why it wasn't suitable or available. This documentation is crucial later on, especially if there's a question or dispute about whether they met their obligation.
Okay, so they have to show their work, basically.
Exactly. What's fascinating here is the depth of the obligation. It's not just a passive waiting game, it's a mandated, documentable process they must actively pursue. This raises an important question. What happens then if, despite genuinely making every effort and searching thoroughly, management determines there truly is no suitable work available within your restrictions at that moment?
Right. That brings us back to the scenario we started with, the dreaded no work available outcome. If management determines there's truly no work within your restrictions, they inform you and you are sent home.
Yes, but here's another key insight. USPS's responsibility to look for work doesn't end when you're sent home.
Oh, really?
The search is supposed to be ongoing. Union sources suggest this search should continue, even daily. Management shouldn't just give up looking.
Okay, so you're sent home, no work available right now. What's the immediate, critical action you as the employee need to take to protect your income and status? This is where it shifts from USPS's duty to your action.
This is where you absolutely must engage with the Office of Workers' Compensation Programs, or OWCP.
OWCP.
OWCP is a program under the Department of Labor that administers the Federal Employees Compensation Act, FECA. This is the federal workers' comp program that covers USPS employees injured on the job.
Okay, OWCP is your safety net for lost wages. How do you actually start claiming that wage loss when you're sent home because there's no work?
The core mechanism for getting paid when you're off work due to an accepted injury is filing Form CA-7, the claim for compensation.
CA-7, got it.
You file this form with your employing office at USPS, usually their injury compensation office. USPS is required to assist you and promptly forward it to OWCP. The CA-7 covers the specific pay periods you were unable to work. Filing these forms timely is critical. Generally, you file them every 2 weeks, or sometimes OWCP might place you on the periodic rolls for more automatic payments after a longer absence.
Every 2 weeks. Okay. Now, what if you had returned to a limited duty job for a while, perhaps for months or even years, and then that specific job was withdrawn or eliminated, and you were sent home because no other suitable work was found? Is that just a standard CA-7?
That's a slightly different scenario and requires an additional step. In that case, it's treated as a recurrence of disability.
The recurrence.
Yes. You need to file not only the CA-7 for the time lost, but also Form CA-2A, Notice of Recurrence.
CA-2A.
This form signals to OWCP that your current inability to work stems from your original injury, but it's a recurrence because the limited duty job you were performing was withdrawn. You'd explain this on the CA-2A, perhaps writing something like, no work available, limited duty position withdrawn.
Makes sense.
And it's highly recommended to attach any documentation you have about the limited duty job being offered and subsequently withdrawn. Proof helps.
So CA-7 is the form for claiming the money for lost time. CA-2A is specifically for when you were working and then lost that work due to the injury again. Got it. Now, how do you keep showing OWCP that you still can't work your regular job? What medical documentation is needed ongoing? This seems crucial.
This is arguably the most vital part for the employee to manage diligently. You must provide continuous medical evidence documenting your specific work restrictions. OWCP needs proof that your inability to work is ongoing because of the accepted work injury.
And the primary form for that is the one we hear about a lot, the CA-17.
Yeah.
Is that right?
It's exactly. Form CA-17, the duty status report. Think of this as the key communication tool between management, your doctor, and OWCP.
Okay.
It has two sides. One side is where your supervisor describes the duties of your job or potential limited duty tasks, and the other side is where your doctor details your medical limitations, specific restrictions on lifting, standing, sitting, bending, reaching, all that.
Right, the nitty-gritty details.
You need to take this form to your doctor regularly whenever your restrictions change, or at a minimum every 30 days while you're out of work due to the injury. Your doctor needs to be specific and clear. You give copies of the completed form to USPS and OWCP. This form directly supports why you cannot do your regular job or any other work management might identify by linking your limitations to specific tasks.
So the CA-17 is like your doctor's ongoing note explaining why you're still restricted.
Yeah.
What about other medical reports? Are those needed too?
Yes, doctors should also provide narrative medical reports, sometimes using Form CA-20. These reports give more detail than the CA-17. They explain the diagnosis, how it's related to your work injury, the treatment you're receiving, and your prognosis for recovery.
More context.
Exactly. OWCP uses these reports to get a fuller picture of your condition and its impact on your ability to work. You generally need to provide updated reports, say, every 30 to 60 days while you're receiving compensation.
Okay, so consistent medical updates are key. While you're out and filing these forms, what's your official employment status with USPS? Are you fired? On leave?
Typically, you'll be placed on leave without pay, LWOP, under a specific OWCP code by USPS.
LWOP, OWCP.
Right. This indicates that your absence is due to an accepted work injury and OWCP is handling the wage replacement. While you could use sick or annual leave, using LWOP under the OWCP code keeps it cleaner and signals that you're awaiting or receiving OWCP benefits. Continuation of pay, or COP, that's only for the first 45 days following a traumatic injury. After that, it's the CA-7 process for wage loss.
Okay, LWOP. Does that time on OWCP, LWOP key count towards anything with USPS, like retirement or leave accrual?
Yes, that's important to know. While you don't accrue sick or annual leave while on OWCP, LWEP, that time does count toward your creditable service for retirement eligibility and for calculating your leave accrual rate if you return to USPS employment later. So it's not totally lost time.
Good to know. What if OWCP payments are delayed, which, can happen sometimes? Is there anything an employee can do in the meantime for income?
Well, if OWCP payments are significantly delayed, or if your claim is initially denied, you might be eligible for unemployment compensation as an interim measure, depending on state laws. You'd typically apply using Form SF-8.
SF-8 for unemployment.
But, and this is important, you generally cannot receive both OWCT benefits and unemployment benefits for the same period. It's usually one or the other.
Okay, so you're home managing the medical side, the OWCP paperwork. Do you just wait by the phone, or do you have to stay available? What happens if USPS does find work for you later on?
You absolutely must remain available for suitable work and inform USPS immediately of any changes in your medical condition that affect your work restrictions. You can't just disappear.
Yep.
If USPS does find a job or a collection of tasks that they believe fit your current medical restrictions, they're required to issue a written job offer.
A formal written offer. And I assume you have to respond to that? You can't just ignore it.
Yes, you absolutely must respond to any written job offer from USPS. OWCP will evaluate whether the offer constitutes suitable employment based on your documented medical restrictions. It is highly recommended that you have your doctor review the written job offer to confirm whether it meets your limitations.
Get the doctor's opinion on the offer itself. Makes sense. What are the consequences if you refuse a job offer that OWCP decides was suitable for you?
This is a critical point. Refusing a medically suitable job offer from USPS can lead to the suspension or termination of your OWCP wage loss compensation.
Wow, okay, so you lose your pay.
Potentially, yes. OWCP views it as you declining an opportunity to work within your capabilities.
But what if you or your doctor genuinely believe the offer is not suitable, that it's unsafe or exceeds your restrictions? You're not just stuck accepting it, are you?
No, definitely not. If you believe it's unsuitable, you should immediately communicate that to both USPS and OWCP, providing clear medical justification from your doctor explaining why the offer is not suitable. Don't just ignore the offer.
Document the refusal.
Yes, and explain why. You should also involve your union representative. They can review the offer against the requirements of ELM 545546 and potentially challenge its suitability through the grievance process if needed.
Okay. Beyond responding to job offers, what else does OWCP require you to do to keep your compensation flowing? Are there other hoops to jump through?
Yes, you must comply with OWCP's requirements. This includes responding to any requests for information they send, such as forms asking about any outside income, like Form EN 1032.
Reporting income.
Attending any medical examinations OWCP directs you to. These are often second opinion exams or referee exams if there's conflicting medical evidence. And importantly, cooperating with vocational rehabilitation if OWCP assigns you a counselor.
Vocational rehabilitation. What exactly is that in this context? Sounds serious.
In longer-term injury cases, OWCP may assign a rehabilitation nurse or counselor. Their role is to help you return to work, either by identifying suitable jobs within USPS that match your restrictions, or even helping you explore job options with other employers.
So they might try to find you work outside the post office.
They might, yeah. They could help with resume writing, job searching, or skill development. Now, failure to cooperate with these vocational rehabilitation efforts, like refusing to meet with the counselor or apply for jobs they identify, can also lead to suspension of your OWCP benefits.
So you have to cooperate with the rehab efforts.
You do. OWCP might also conduct a loss of wage earning capacity assessment, or LWEC. Based on vocational findings, they determine what you could theoretically earn in a job you're capable of performing, even if it's not your old job.
Okay.
They could then pay you partial compensation based on the difference between your pre-injury wage and this potential earning capacity. This LWEC determination can change if a suitable job offer comes up later, either from USPS or elsewhere.
So maintaining eligibility for OWCP wage loss boils down to diligently filing your CA-7s, providing continuous medical evidence showing your restrictions via updated CA-17s and medical reports, reporting any income, and cooperating with OWCP requirements like exams and rehab. That's a significant amount of personal responsibility alongside the employer's duty.
It really is. It requires active participation from the injured employee.
So as you can see, navigating this involves a whole lot of forms and procedures. But the insight here is that understanding why these documents are needed is absolutely key to protecting yourself and navigating the system successfully.
Right. This raises an important question. What specific documents should an injured employee really focus on keeping track of? And why is keeping personal copies of everything so critical? Let's really nail down the paper trail.
Let's dig into that. You'll have the initial CA1 or CA2 reports that started the claim, okay, but the forms you deal with while you're off work or in this no work available status are the core of your documentation.
Absolutely. The CA-17 is, as we said, the medical roadmap. It's the crucial piece that shows both USPS and OWCP exactly what your doctor says you can and cannot do.
It justifies the restrictions.
Right. It's the document that justifies why you can't do certain tasks or jobs. Getting this updated regularly, at least monthly, with clear and specific limitations from your doctor is non-negotiable for continuing OWCP compensation.
Okay, CA-17 number 1, and the CA-7 is the actual claim for money.
Correct. You filed the CA-7 to request wage loss compensation for specific pay periods you missed work due to the accepted injury. USPS certifies that you were off work and weren't offered suitable work, and then sends it to OWCP for payment processing. For intermittent absences, maybe you work some days but not others, you'd use the CA-7A.
CA-7 or 7A for pay. And the CA-2A, again, specifically for that scenario where you went back to a limited duty job and then lost it.
Yes, exactly. Use the CA-2A if you had returned to work in some capacity after your initial injury report and acceptance, and then had to stop working again because your original injury flared up, or critically in this scenario, because the limited duty assignment was withdrawn and no other suitable work was available. It flags it as a recurrence of the original claim for OWCP.
Got it. What other documents are vital to keep copies of? You mentioned medical reports.
Yes. Any medical reports from your treating physicians beyond the CA-17 narrative letters, doctor's notes, test results, Form CA-20s. These provide the medical details behind the restrictions on the CA-17, the diagnosis, the treatment plan, the prognosis. OWCP needs these periodically, like every 30-60 days, to continue justifying your ongoing disability and need for compensation.
Okay, keep all the medical stuff and any job offers from USPS.
Absolutely essential. Any offer of suitable work from USPS should be in writing. These letters detail the proposed duties, schedule, location, and pay. You will likely be asked to sign indicating acceptance or refusal.
Right.
And you should provide your reasons if refusing, supported by medical documentation from your doctor. USPS sends these offers and your response to OWCP, who will then review them to determine if the offer was suitable and if your refusal was justified. This document is central to any dispute about suitable work. Keep your copy. And while you might not always get copies automatically, internal USPS documents like the PS Form 2499, which is sometimes used for limited duty offers, and those 546 worksheets documenting their search efforts are also important. Often, the union might obtain these during a grievance investigation to show whether USPS truly made every effort.
Right, those internal docs can be revealing. We briefly mentioned PS Form 50 earlier. What does that personnel form signify in this situation? Could you get one?
Yes, you could. PS Form 50 is the standard form for personnel actions. If you are continuously unable to work for a year due to your accepted injury and are receiving OWCP compensation, USPS may medically separate you via a PS Form 50, listing inability to perform duties as the reason.
Medically separate.
Hmm.
Sounds like getting fired.
It's a change in your employment status with USPS. It's not disciplinary. But critically, it does not automatically end your OWCP benefits. You essentially become a former employee on the OWCP rolls, still potentially eligible for wage loss and medical care related to the injury.
Ah, okay. So it's a USPS status change, not an OWCP benefits change necessarily.
Correct. And if you have appeal rights with the Merit Systems Protection Board, MSPB, like if you're a veteran or have sufficient years of federal service, you can potentially appeal their medical separation itself to the MSPB.
Okay. So summarizing the documentation piece, CA7s for pay, CA17s for restrictions, CA2A if needed for recurrence, all supporting medical reports, and copies of any job offers and your responses. Those are the absolute must-haves in your own file. And the golden rule is,
Keep copies of everything. Every single form you file, every letter you receive from USPS or OWCP, every medical report from your doctor, every job offer, every response you send. Make copies before you send anything. This paper trail is your absolute best defense. It's your proof of filing, your medical support, and your record of communication. If there's a dispute, an appeal, or a grievance down the road, your copies of these documents are essential evidence.
so while the paperwork is significant, it's also your most powerful tool. Okay? This whole process, especially being sent home, can feel incredibly daunting. Like the system is designed to make you give up. But the sources we reviewed make it abundantly clear that injured employees are absolutely not without rights.
Absolutely not. If we connect this to the bigger picture, while the system is complex, maybe even feels a labyrinthine sometimes, it's layered with protections. Injured employees have significant rights and multiple avenues for challenging decisions, ensuring their employer meets their obligations and receiving the support they're entitled to by law.
Okay, let's talk about those layers of protection.
Uh-huh.
What are the main rights an employee has in this scenario when they're injured and maybe told there's no work?
Well, first and foremost, you have the fundamental right to OWCP compensation. That's the wage loss and medical expense coverage for an accepted work injury. That's the ECA law. While USPS helps facilitate the claims, OWCP is the federal agency that makes the final decisions on your benefits.
Okay, right to benefits.
And importantly, if OWCP denies your claim or reduces your benefits, you have specific rights to appeal their decision, which is separate from appealing anything USPS does internally.
What does appealing an OWCP decision involve? Is that complicated?
There are several routes. You can request an oral hearing with OWCP's branch of hearings and review. You can ask OWCP for a reconsideration based on new evidence or argument, or you can appeal to the Employees Compensation Appeals Board, ECAB, which is an independent board outside of OWCP. So there are layers of review available.
Okay. What about getting back to work if your condition improves? Are there rights around actually returning to USPS?
Yes, these are called restoration and retention rights found in federal law and also detailed in ELM 546. This is another key insight. If you fully recover from your injury, and it's within 1 year from the time you started receiving OWCP compensation,
Within a year.
you are entitled to return to your former position or an equivalent one. USPS must give you that job back. It's a strong right.
Okay, that's powerful. And if it takes longer than a year to fully recover?
If you fully recover after more than 1 year, you get priority consideration for reemployment into an equivalent position. Your name goes on a reemployment list, basically.
Priority consideration.
And if you only partially recover but can still work within restrictions, even if you were medically separated via a PS50, you still have the right to be considered for any rehabilitation assignment within your limitations. ELM 546 gives partially recovered employees the same priority for these assignments as current employees meeting limited duty.
So even after a medical separation, if you partially recover, they still have to consider you for suitable work.
Yes, those restoration rights persist for partially recovered former employees, too.
So if USPS violates those restoration rights, like they refuse to take you back when you fully recovered within a year, or they don't give you proper consideration as a partially recovered employee, is there recourse? Can you fight that?
Absolutely. If you have appeal rights to the Merit Systems Protection Board, the MSPB, which applies to many federal employees, including those at USPS with veteran preference or sufficient service time, you can appeal USPS's violation of your restoration rights directly to the MSPB.
The MSPB again?
Yes.
Yeah.
ELM 546.4 explicitly allows this for partially and fully recovered employees. The MSPB is an external federal body that can review USPS's actions and order them to comply if they find a violation.
Okay. Now, are you protected from being disciplined just because you're injured or because maybe your productivity might be slower if you were working with restrictions?
Yes, this is another important protection area. You cannot be disciplined by USPS for absences that are covered by an accepted OWCP claim. That time off is protected leave, essentially.
Can't discipline for being off on comp.
Correct. Furthermore, if you are working in a limited duty or rehab assignment within your restrictions, you should not be disciplined simply for low productivity compared to a full-duty employee. The standard is performing a fair day's work for a fair day's pay to the extent you are able within your medical limitations.
Okay, fair standard based on ability.
Mm-hmm.
And if there's harassment or pressure to work outside your doctor's restrictions, that happens, right?
It shouldn't, but yes, it can. That's also not allowed. It could certainly be a basis for a union grievance. Additionally, the Rehabilitation Act protects employees from discrimination based on disability. If you believe you have been discriminated against, harassed, or denied a reasonable accommodation due to your medical condition stemming from the injury, you have the right to file an EEO complaint with USPS's EEO office.
EEO is another avenue. For union employees, the union grievance procedure seems like a really powerful tool here to enforce the rules in the ELM, like Section 546.
It absolutely is. The collective bargaining agreements allow employees and their unions to file grievances challenging management's actions that violate the contract or incorporated policies like ELM 546. This is a major enforcement mechanism.
So you can grieve things like failure to search properly.
Exactly. Grieving the failure to properly search for suitable work, offering jobs that don't actually meet your medical restrictions, or improperly withdrawing a limited duty assignment without just cause. These are common subjects of grievances in this area.
And a grievance can actually lead to a resolution that forces USPS to correct the situation. Like, what can an arbitrator order?
Yes. If a grievance goes to arbitration, an arbitrator issues a binding decision. Arbitrators can, for example, order USPS to reinstate a limited duty assignment that was improperly withdrawn, or award back pay for the time an employee was improperly kept out of work because USPS failed its obligation to find suitable work when it was actually available.
Back pay.
Okay. Unions can use management's own documentation, like those 546 worksheets we talked about, potentially along with witness statements, to prove that suitable work could have been made available, citing precedents like the make work concept from the DAS decision.
Using their own records against them, potentially. And you have the right to have your union representative involved in discussions about your limited duty or injury compensation status, right? You don't have to go it alone.
Yes, absolutely. Union representation is a right in any meeting or discussion concerning these matters where your contractual rights might be affected. Always ask for your steward if you're unsure.
Okay. What about that medical separation via PS50 we discussed? Can that also be appealed beyond the restoration rights aspect?
Yes. If you have MSPB appeal rights and USPS removes you through a medical separation, PS Form 50, you can appeal that removal action itself to the MSPB. The MSPB will review whether the removal was procedurally correct, if USPS met its obligations regarding suitable work and restoration before separating you, and whether the separation was otherwise justified under the law.
So the MSPB looked at the whole picture of the separation.
Right. And the MSPB has even handled class appeals related to system-wide actions affecting limited duty employees, like aspects of the National Reassessment Process, or NRP, that impacted many injured workers some years back.
Okay, so to summarize the rights and appeals, you've got OWCP appeals if OWCP denies benefits. You've got MSPB appeals for violations of restoration rights or improper medical separations. You've got EEO complaints for discrimination. And you've got union grievances for contractual or policy violations, like failure to find suitable work. It sounds like you could potentially pursue multiple paths at once.
That's a key insight from union guidance on this topic. You often can and sometimes should pursue different avenues simultaneously, if applicable. Filing a grievance about the lack of suitable work through the union, for example, doesn't prevent you from appealing an OWCP decision on your benefits, or filing an EEO complaint if you think discrimination was involved. The goal across these different systems is often to be made whole, either by getting back to suitable work you can do, or by receiving the compensation you're entitled to because work wasn't available, or sometimes both, depending on the specifics.
Made whole. Okay. This whole process involves so many moving parts and different entities. Local management, OWCP, doctors, unions, maybe MSPB or EEO. So who within USPS is actually supposed to be coordinating all this? The sources highlight the crucial role of the Injury Compensation Office.
That's right. This office, sometimes called the Health and Resource Management or HRM office, depending on the structure, serves as the primary administrative hub for injury cases within USPS. Think of them as the liaison connecting you, your local managers, and OWCP.
The central coordinator.
Yes, but it's important to remember, though, that while they administer the rules and provide information, they ultimately represent the employer's interests in this process. They work for USPS.
Good point. So what are their key responsibilities in this no work available situation specifically?
Well, a major role is facilitating your OWCP claims. They provide you with the necessary forms like the CA-7, assist with completing the employer's portion, and are responsible for submitting them promptly to OWCP. They manage the initial 45-day continuation of pay, if applicable, and track your transition to LWOP under the OWCP code. They are usually the main point of contact within USPS for OWCP regarding your claim status.
Handling the OWCP paperwork flow. And when it comes to finding that suitable work or determining it's not available?
They coordinate the job search efforts with local managers. They are responsible for ensuring that the ELM 546 priority search is conducted properly. They should ensure that any job offers are put in writing, clearly describe the duties, and crucially, that they meet your medical restrictions as documented by your doctor.
Making sure offers are legit.
Right. They might consult with a USPS medical officer or coordinate with a Department of Labor nurse from OWCP to verify the medical suitability of a proposed assignment before sending the offer to you. And importantly, they also send copies of job offers in your responses to OWCP.
So they're the ones keeping track of that documentation of the search we talked about, the 546 worksheets.
Exactly. They maintain those records, like the 546 worksheets, partly to demonstrate that every effort was made to find suitable work. This documentation is what USPS will use to defend its actions if challenged in a grievance or appeal. For the employee or union, getting access to these documents, often through the grievance process, can be vital evidence.
Gotcha.
They also play a role in ensuring compliance with the rules internally. They advise local managers on what work can and cannot be assigned based on restrictions and ensure compliance with regulations, including the requirements of the Rehabilitation Act regarding reasonable accommodation. They might involve their local district Reasonable Accommodation Committee, or DRAC, in complex or long-term cases. They are supposed to be protecting both the employee's rights and the Postal Service from, well, legal errors.
A compliance role, too. Are they supposed to communicate with the injured employee directly should you be hearing from them?
Yes. They typically serve as the primary point of contact within USPS regarding your injury claim and work status. They might send initial letters outlining your OWCP rights, provide guidance on medical bills, and are supposed to maintain contact with employees out on OWCP to check on recovery status and remind them about documentation needs, like getting those CA-17s updated. It's also their office you should notify first if your medical restrictions change.
Okay, so they're the main USPS contact point.
Yeah.
How about long-term cases or those medical separations we mentioned?
They are involved in managing long-term injury files. Before medical separation, using a PS50 is considered after a year of continuous absence. The Injury Comp Office is usually consulted to ensure all procedural requirements and obligations, like searching for work, have been met. And even after separation, if you medically recover later, they might handle referrals from OWCP regarding your potential reemployment rights under those restoration rules.
So they're involved end-to-end, potentially.
Pretty much. Essentially, they are the administrators who are trying to balance your medical needs and regulatory rights with the agency's operational needs and budget constraints. It's a balancing act.
Which really reinforces the value of having your own support, like from a union representative, involved in the process, doesn't it? To make sure your side is fully represented.
Absolutely. While the Injury Comp Office is a necessary part of the process and can provide information, they represent the employer. Having your union involved ensures that your rights and interests are fully protected and advocated for, adding another layer of checks and balances to the system.
Makes sense.
Ideally, the process works collaboratively. Your doctor defines your limits, Injury comp works to find work within those limits if available. OWCP provides compensation if work isn't available, and you focus on recovery. But understanding the distinct roles and having informed support is absolutely crucial for navigating it successfully when things get complicated.
Okay, so to recap this deep dive, if you're an injured USPS employee with medical restrictions and find yourself in that difficult situation where no suitable work is immediately available, you are absolutely not without options or rights. That's the main takeaway.
Definitely. A key insight is that USPS has a mandated legal and contractual obligation under ELM 546 and federal law to make every effort through a documented, prioritized process to find you suitable work within your restrictions. That includes make work.
Right. And if, after making those efforts, they determine no work is available right then, you are sent home. But the crucial point is that their responsibility to look for work doesn't end. It's supposed to be ongoing.
When sent home, navigating the financial gap relies heavily on the Office of Workers